This is part 2 of the antitrust presentation. So we've talked a little bit about the differences between Section 1 and Section 2 of the Sherman Act. So let's take a little bit further look at each section. So with regard to Section 1 of the Sherman Act, we've got per se violations, the rule of reason, horizontal restraints, and vertical restraints, which are actually both subject to the rule of reason. So per se violations, this is a restraint of trade that is so anti-competitive that it is deemed inherently illegal. So these are, this is when, a business engages in business practices that are just obviously putting some type of restraint on trade and that are obviously in violation of antitrust laws. The rule of reason is a test that courts use to, evaluate a situation, determine whether or not a business or businesses are in violation of antitrust laws. Courts consider such factors as the purpose of the agreement, the parties' ability to implement the agreement to achieve the purpose, the effect of the agreement on competition, and the possibility of using less restrictive means to achieve its purpose. Horizontal restraints. Price fixing is an agreement between competitors to fix the prices of products or services at a certain level. So going back to our basketball example, this would be if Wilson, had a meeting with Spalding, and they said, why don't we just raise our prices to $200 for a basketball? Consumers won't have a choice. If they want a good basketball, they'll have to pay $200 for one. Group boycotts. This is an agreement between two or more sellers to refuse to deal with a particular person or firm. It's pretty self-explanatory. Market allocation. Now, I believe this one is referred to in the textbook as horizontal market division, but it's an agreement among competitors to effectively split the market and minimize competition with each other, giving them the ability to raise prices and prevent new competitors from entering the market. So, this would be if Wilson, had a meeting with Spalding and they said, as Wilson, we're just going to make basketballs, and why don't you guys, y'all can just make footballs, and we won't have to compete with each other. We'll just we'll dominate the market. So bid rigging. I don't think this one is addressed in the textbook, but I thought it was a good one, and so I went ahead and included it. But bid rigging is a scheme in which businesses collude during a bidding process so that a competing business can secure a contract at a predetermined price. It stifles free market competition as the rigged price will be unfairly high. So for example, let's say UCA wanted to build a new dorm. So a lot of times when a university, wants to build a new building, they'll invite these big contractors to submit bids. That way they can pick, the lowest price, to get the job done. But let's say these contractors got together and they said, well, why don't we, figure out who's the best for the job, and then, we'll designate the job to that person or that contractor, and we'll all submit really high bids, but we'll allow this designated contractor to submit a bid that's a little bit lower, but it's still unreasonably high. So vertical restraints, territorial or customer restrictions. This is where a manufacturer attempts to institute territorial restrictions or prohibit wholesalers or retailers from reselling the product to certain classes of buyers, such as competing retailers. So, like I said, these horizontal and vertical restraints are subject to the rule of reason, which means that courts have to look at situations on a case-by-case basis and determine whether or not, they are putting some type of unfair restriction on trade or are actually in violation of antitrust laws. Sometimes, businesses have, an acceptable, reason for, imposing these type of restrictions. And so that's why, they have to look at each situation on a case-by-case basis. So resale price maintenance agreements. These are agreements between a manufacturer and a distributor or retailer in which the manufacturer specifies what the retail prices of its products must be. So a good example of this one would be Tempur-Pedic beds. Not too long ago, I was looking at maybe getting a new bed, and went to mattress firm, I believe it was, and I had a conversation with one of the salespeople, and they actually told me that Tempur-Pedic regulates the price on their beds. That way, their retailers and their distributors have to charge the same price. This seems to benefit the retailer a little bit more than the manufacturer, in my opinion. But what do I know? So Section 2 of the Sherman Act. Now, like I said, Section 2 actually addresses the attempt to establish a monopoly, whereas Section 1 addressed the actual act of doing so. But dominant market share may be the result of successful management, or business efficiency, or the development of a superior product. So that's why the Section 2 establishes what they call the intent requirement. If a firm possesses market power as a result of carrying out some purposeful act to acquire or maintain that power through competitive means, then it is in violation of Section 2. So, basically, this is saying that you actually have to purposefully, engage in unfair or non-competitive, business practices, in order to be in violation of Section 2. So, I think this is really important for accountants, lawyers, and business professionals to understand. That way, if you go off to start your own business, or you find yourself managing, a business that is, has, a monopolistic, position, just keep in mind that, you're not necessarily in violation of antitrust laws unless you actually engage in, unfair business practices. So let's talk a little bit about the Federal Trade Commission Act. This one was established in 1914. It actually created the Federal Trade Commission. The Federal Trade Commission is an independent agency of the U.S. government, and is tasked with enforcing the nation's antitrust laws and promoting customer protection. It bans unfair methods of competition and unfair or deceptive acts or practices. The U.S. Supreme Court sees all violations of the Sherman Act to also be in violation of the FTC Act. The Federal Trade Commission does not technically enforce the Sherman Act. However, it may bring cases against those who have violated the same kinds of rules outlined under the Sherman Act. So the Clayton Act. This one was also established in 1914. This act addresses specific business practices that the Sherman Act does not clearly prohibit, such as mergers and interlocking directorates. If one person was, served on the board for two companies that competed with each other, so this would be in violation of the Clayton Act. It prohibits mergers and acquisitions where the effect may be to substantially lessen competition or to create a monopoly. It was amended in 1936 by the Robinson-Packman Act. So this amendment actually, banned certain discriminatory practices or prices, services, and allowances in dealings between merchants. It was then amended again by the Hart-Scott-Rodino Antitrust Improvements Act to require companies that are planning large mergers or acquisitions to notify the government beforehand. So let's talk about enforcing antitrust laws. Who is responsible for enforcing antitrust laws? Antitrust laws are enforced by the U.S. Department of Justice, and the Federal Trade Commission. Only the DOJ can prosecute violations of the Sherman Act, and only the FTC can prosecute violations of the FTC Act. Violations of the Clayton Act are actually not crimes, but can be enforced by the DOJ or the FTC through civil proceedings.